in the appeal, the Queen on the application of Bashir and others, and the Secretary of State for the Home Office.
Yes, Mr. Reedy.
Lady, my lords, good morning. You have the cast list and the order in which the submissions are going to be made to the court. That's acceptable. I wasn't going to go through those unless you'd like me to. There is, I understand from Mr. Hussain, a question of anonymity order. I don't know whether the court has had any thought about that, but it's not my application. It's Mr. Hussain's if he wants to make it. So.
Well, perhaps Mr. Hussain might like to mention it. These are refugees. So the standard that verb of asylum seekers reason doesn't apply. So what reason is there to anonymise these respondents?
There are children involved,
yes.
lady, and that was the basis on which the anonymity order was made below at first instance, in respect of all of the respondents other than the first respondent.
But the mere fact that children are involved because their parents are involved is not usually a reason for anonymising.
That was the basis.
Right now. Yeah.
Also, in our respectful submission, the division in the court's practice has been, and I've no desire unnecessarily to contribute to alphabet soup, obviously, but the division has been between failed asylum seekers on the one hand and people with pending claims or people who are recognised as refugees. It is particularly important for them. Could I invite you to extend it pro tem, extend the order that was made below pro tem, and address you further on it?
Well, you know I'm really, really reluctant to make anonymity orders unless they are necessary. And so I will extend it for the time being, but we'll have another word about it and see what my lords think about this.
There's also evidence of psychological problems and so forth you may have seen in the material.
But there is, of course, but that doesn't, I mean,
no.
I'm afraid these are reasons that apply almost universally,
yes,
where individuals are involved in litigation.
I have Lord Rogers' strictures in mind.
Yeah. So, we'll leave it at that until the short adjournment.
Thank you very much.
Yes.
My lady, I was proposing to take you briefly, I hope, through the core chronology and some of the facts, then make some brief submissions on issue 1, the application of the Refugee Convention to the SBAs. Then I was going to turn probably this afternoon, I suspect, to issues 2 and 3, which I'm going to take together, if that's an acceptable order. So on issue 1, the core facts. Firstly, the island of Cyprus was annexed in 1914. We don't need to turn it up, but if you want it, you find the annexation order at core volume 3, if I can call it that. It's also appendix part 1b, but I'm going to call it core volume 3. Core volume 3, tab 22, MS, and all the page numbers I'm going to give you are the electronic ones from now on, 873. It had previously been held on assignment from the Turkish government, one assumes as part of the settlement of the Crimean War, since 1878. And if you want the documentation relating to that historical setup, Authorities 2, tab 17, page 3538, and Authorities 2, tab 13, 3408. Secondly, it was known as a colony, having been annexed, as I've said, in 1914. It was known as a colony from 1925, when letters patent so provided. And the basic structures of the government as a colony you find set out in core volume 3 again, and it may be worth just having that to hand so one can flick through and see it as you go, if only to show you the shape of the document. It's a bit soulless without. Core volume 3, tab 23. These are the letters patent.
And the page?
It's page 874 is the start of it. But you see the basic structures of government on page 875 and following, with the substitution of a governor for the High Commissioner who'd previously been in place, a third of the way down page 875, setting out the governor's powers and authorities. Further down that page, power of legislation reserved to the Crown, as one sees from Article 9, halfway down page 876, and at the top of that page, an executive council consisting of the people you see referred to in clause 6.
I think that's Article 11, isn't it?
Yeah.
It's Article 11. I'm so sorry, my lady. It is, yeah. The powers of legislation reserved to the Crown. Sorry. Then, thirdly, in 1956, and coming closer to the issues at hand, the United Kingdom extended the Refugee Convention of 1951 to, quote, Cyprus. Cyprus was at that date, as I've said, a colony. The United Kingdom had signed the Refugee Convention on the 28th of July 1951 and had ratified it on the 11th of March 1954 with a declaration at the date of ratification extending it only to the Channel Islands and the Isle of Man. One gets that perhaps most conveniently collated, that little group of facts, in Mr. Justice Foskett's judgment below at paragraph 182. So as I've said, on the 24th of October 1956, the United Kingdom declared that the Refugee Convention extended to the territory of Cyprus pursuant to Article 40, sub 1 of the Refugee Convention. And you have the documentation, so far as that is concerned, in the same volume, core volume 3, behind tab 26, on page 939. As one sees from that document, the first document at 939, which is the United Kingdom declaration or notification, more accurately, in relation to Cyprus, you see the second paragraph of that letter of the 24th of October 1956, consultation with the governments of other territories for the conduct of whose international relations the UK are responsible have since taken place. These consultations have now been concluded in the case of the territories named below, and accordingly, in respect of those territories, I have the honour to notify the UN on behalf of the Government of the UK in accordance with Article 40 sub 2 of the above-mentioned convention, that's the Refugee Convention, that the convention shall extend to the territories of, and then you see a list of territories, including Cyprus, and bearing in mind Bonku, and the litigation in relation to Bonku, Mauritius and the Seychelles also. But you see the reason for the hiatus or the delay, as it were, between the declaration on the date of ratification extending to the Channel Islands and the Isle of Man, which was a couple of years earlier, over 2 years earlier in 1954, and this declaration. It was because consultations, according to this letter, had been occurring with those other territories, including Cyprus. And once
Has there been any change in the governmental arrangements for Cyprus between 1925 and 1956, or was it all still basically run by the governor?
Not as far as I'm aware, all still run by the governor. So
the consultation will have been with the governor?
The consultation will probably have been with the governor, and we don't know precisely what consultations the governor might have had with locally elected representatives or any of the institutions that existed on Cyprus. But we don't have in evidence the nature of those consultations. But I think the overall system of government had remained the same, as my lady says. But those consultations, at least the fact of them, in relation to all of those territories is the reason why there was that delay. And you will see that in relation to those territories, a series of reservations are made. So you notify or declare in relation to a territory, and reservations are also made at the same time as the notification, altering, in effect, various provisions of the Refugee Convention. And one sees those at Roman 1 to Roman 4 on pages 939 to 940.
3 and 4 talk about what the government of the United Kingdom will and will not undertake, Mr. Eady. And so I don't think you dispute this was the UK government undertaking things.
My Lord, I don't, because that is the setup. We'll come to it in a bit more detail in a moment, but Article 40, declarations or notifications are only given and can only be given by the state which is responsible for the international relations of these territories. So it is proper and right that the United Kingdom so undertakes, but they are undertaken, I'll come to this in a bit more detail in a moment, but they're undertaken on behalf of, in effect, those territories with the consultations that you see having occurred.
And I suppose your point will be, in due course, will it, that insofar as there are qualifications on the undertakings, that indicates that this is more like a patchwork than a completely seamless web.
My Lord, exactly so. It's all part of the same theme. The theme is going to be that these declarations are made on behalf of territories which have their own interests, to some extent their own systems of government, more or less representative, more or less autonomous, and the system involved declarations or notifications being given on behalf of, or if one takes the French text, as representatives of those states. But that doesn't diminish the answer that I gave to my Lord Wilson, which is that as a matter of international law, these undertakings are properly given, if for diplomatic reasons, by the UK as the state which is responsible for their international relations. So you see the reservations that are there set out 1 to 4, and you also see on a similar theme, you see that some of the reservations are different as between the various territories, no doubt reflecting the local conditions. So one sees in B, on page 940, that the convention shall extend to the territories of Zanzibar and St. Helena, with the reservations 1, 3, and 4, but evidently not 2. But again, that is reflective of these being, there being specific issues relating to these territories which shape both the way in which this is done and the reservations. And you see in the penultimate paragraph on page 940, further notifications will be made as and when consultations with the remaining territories for the conduct of whose international relations the government of the UK are responsible are likewise concluded. So there will be other territories beyond those listed in A on page 939 where the consultations are still ongoing and further reservations might or might not be made. Further notifications, rather, might or might not be made. So that is the basis on which the territory, in inverted commas, of Cyprus, in inverted commas, was made in 1956. And the relevant provisions of the Refugee Convention, and for the moment I'm going to make submissions on them in due course, but for the moment, can I just identify them? They are, I think you've got it in a variety of different places, but in this same bundle, if you're here, the one and the other reference I'm going to give you is in slightly bigger type. So if anyone wants a slightly bigger type, they can go there. But if you're in this bundle, it's behind tab 24, where you will find the Refugee Convention itself and indeed the protocol, page 879. And the reference for those who want bigger type is Authorities 1, tab 5, page 3123. But if I may take it from tab 24, and just to show you the relevant provisions, Article 40 is at page 913. And it provides, in relevant part, as you see, any state, I'm reading from 1 sub 1 in Article 40 on page 913, any state may at the time of signature, ratification or accession declare that this convention shall extend to all or any of the territories for the international relations of which it is responsible. Such a declaration shall take effect when the convention enters into force for the state concerned. So that was the provision that was used in relation to the Isle of Man and the Channel Islands in 1954. Sub 2 is the one that is relevant because it's a notification that occurs later. At any time thereafter, any such extension shall be made by notification addressed to the UN and shall take effect as from the 90th day after the day of receipt by the Secretary-General of the UN of this notification. And you see in 3, with respect to those territories to which this convention is not extended at the time of signature, ratification or extension or accession, each state concerned shall consider the possibility of taking the necessary steps in order to extend the application of this convention to such territories, subject where necessary for constitutional reasons to the consent of the governments of such territories. And again, that we respectfully submit is all of a piece with the consultations that occurred, a recognition of the need for constitutional reasons, or indeed we would add for practical reasons, for consent from the governments of some of those territories. So that's Article 40.
Do we know, I mean, at the time Cyprus became party to, how many other territories were not still subject to the convention? I mean, do we know the sort of timeline of which British government brought the convention in relation to all its territories?
I don't know the answer to that, but I'll see if I can find out. I think it ended up being, I've got a number of 42 buzzing around in my head, and we saw that there were about 7 or 8 referred to in the document I took you to, and 2 before. But what happened in the intervening 2-year period or the period after, I'm not sure. We'll check.
It may be relevant when considering what duties there are to allow people to move to other territories under the subject, the government to know what other territories there were.
Yeah. We'll check, but you've seen at least the list, which gives you a flavour in the 1956 notification. Article 42, reservations. We saw the reservations that were made in the 1956 notification. That is, those are reservations made under Article 42 on page 914, if I can invite you just to cast an eye down that. And then Article 44, which I'll come back to in a bit more detail, headed denunciation. Any state may denounce this convention at any time by notification addressed to the UN. The denunciation is to take effect under 2, 1 year from the date on which it's received. So there's a lag between the giving of notification to denounce and its coming into effect. Any state which has made a declaration or notification under 40 at any time thereafter, may at any time thereafter by notification of the Secretary-General declare that the convention shall cease to extend to such territory 1 year after the date of receipt of the notification by the Secretary-General. So that's Article 44. And whilst you're there, and just to jump ahead a bit, so we'll obviously have to go back to these under issues 2 and 3, the substantive provisions of the convention which are going to be of interest at that stage are Article 26, page 906, entitled Freedom of Movement. Again, at the moment, I'm just flagging them, just so you know that they're there. Article 32, with its prohibition on expulsion in sub 1, and Article 34, the duties as far as possible to facilitate the assimilation and naturalization of refugees. So those are the relevant provisions of the Refugee Convention. And as I say, we've seen the notification in 1956, which applied it to the territory of Cyprus. So that's the third group of facts, as it were. Fourthly, in 1960, there were fundamental changes giving effect to the fact that a new independent Republic of Cyprus was created, as it was put by the appeal court in the SBAs, the sovereign base areas, in their 13th of September 2011 judgment at paragraph 16 which is in the core volume 3, the one you're in, behind tab 21, starting at page 840, as they put it at paragraph 16 on page 844. In 1960, the Republic of Cyprus was created, and you see the description of how that occurred and of the creation of the sovereign base areas. And they concluded in the third sentence of paragraph 16, undoubtedly, as the respondents put it, this was, as a matter of fact, a fundamental change in the affairs and situation of the island of Cyprus. And as we see from that, the sovereign base areas were a new creation out of small parts of the island to create, in effect, military bases. And as the name suggests, sovereignty over those bases remained in the United Kingdom. If you want a slightly fuller description than the one I've given, I'm going to come to some parts of that new setup in a moment, but a good summary, if I may respectfully say so, of those changes is in Mr. Justice Foskett's very full judgment at paragraphs 55 to 58. And the key elements were as follows. There was a treaty of establishment of the Republic of Cyprus, the newly independent Republic of Cyprus. If you go to tab 27 in core volume 3, you will find that document. Page 942. And for the relevant provisions, and again for your note, Mr. Justice Foskett's judgment, paras 49 to 52, setting out some of the relevant provisions of the Treaty of Establishment. And as one sees from page 942, as one sees from page 943, the first paragraph under the heading and the title of the treaty, this was a settlement concluded by Turkey, Greece, the United Kingdom, and the new Republic of Cyprus. See the first paragraph under the title on page 943. It was signed on the 16th of August 1960, as one sees from the first paragraph on the previous page 942, and it entered into force on signature. See Article 12 of the treaty at page 945. And it set up the new Republic of Cyprus. It included, under Article 8, an assumption by the Republic of Cyprus of all the international obligations and responsibilities of the government of the United Kingdom, so far as they may be held to have application to the Republic of Cyprus, as one sees from Article 8.1 at the bottom of 944. And just, if I may, as a brief diversion, if you keep that open, and one goes to Authorities, tab 7. Sorry to jump around, I'm going to come back to core volume 3 in 1 second, but just to show you some of the writing in relation to the effect of those sorts of clauses. Volume 7 of the Authorities, tab 72, MS 5140, is Professor Crawford's 8th edition of Brandeis Principles of Public International Law. And this Article 8 is the sort of clause that is referred to as a devolution clause, for obvious reasons. Professor Crawford deals with these sorts of clauses at 5143 within tab 72 in the final paragraph just above the forms of territorial change. Can I invite you to read that to yourselves, just to get an idea of it. So good thing in principle, but in terms of international law, the theme is going to be that it's in an advanced state of muddle, so far as this is concerned. And at least one of the problems that is identified is, and perhaps unsurprisingly, you can't, by this sort of bilateral agreement between states, as it were, bind third parties, in other words, the other signatories to the Refugee Convention, to a multinational treaty. And so there are at least significant problems of principle and uncertainties of principle surrounding this. One gets a similar thought from Oppenheim in the same bundle of authorities at tab 83, page 5301 is the first page of it. This is, as you're well aware, Oppenheim's International Law, the 9th edition, edited by Sir Robert Jennings and Sir Arthur Watts. And the relevant part for the purpose of this point is at 5306. Sorry, you perhaps should pick it up at the previous page, 5305. In the final sentence, sorry, the final 4 or 5 lines of the paragraph on page 5305. It's been common, although by no means universal practice, for the parent state and the newly independent state to conclude a devolution agreement, making provision for the continued applicability to the latter of those of the parent state's treaties which extended to the territory of the newly independent state. This practice has been followed in particular by the UK, on the attainment of independence by its dependent territories. The legal effect of such agreement is not altogether clear, but it would seem at least that it clarifies and regulates the position as between the former parent state and the newly independent state, that it does not operate as an assignment of treaty rights and obligations effective in relation to other parties to the treaties covered by it. So that's the Crawford point about not binding third parties, but that it indicates the intentions of the newly independent state in regard to its predecessors' treaties as a formal and public declaration of the transfer of responsibility for the treaty relations of the territory. So that's Oppenheim. And just to complete this little trilogy, sorry, brother. Bottom of the page, I'm invited to show you the bottom of the page, the final paragraph in the footnote. The final paragraph in the footnote, could I invite you to read that at Mr. Hussein's behest? And just to complete the references, as it were, if you have Mr. Justice Foskett's judgment to hand, again, it may be worth having that at the front of the desk, because I'm going to give you some references to this as we go along, given its comprehensive and thoughtful nature, if I can say that with respect. Core Volume 2, Tab 5, page 363 is the first of the pages of Mr. Justice Foskett's judgment. And the relevant paragraph for present purposes is paragraph 257. I think it's on page 432 if you want the MS numbers, but
I'm sorry, could you give me the paragraph number?
Hold on, I'm so sorry, 257.
Thank you very much.
On page 432. And the reason I'm going there for present purposes is just to flag the theme that you've already seen from Professor Crawford and the editors of Oppenheim. You see in particular the reference to the clean slate principle, and he cites from Fawcett and Oust. In particular, a new state will not normally succeed automatically to multinational treaties. A successor state is usually free to choose. So that's the reflection, as it were, of the passages to which I've taken you. Anyway, back to, if we may, back to Core Volume 3, if you still have that open, and the Treaty of Establishment, just to show you some of the key provisions in relation to that establishment. Page 943, we're behind tab 27 again in Core Volume 3. Page 943 on the electronic numbering is Article 1, which defines the territory of the new republic, and the exception, if I can put it that way, is the two areas which are to be called the sovereign base areas, which areas shall remain under the sovereignty of the UK. So there's no question about that. And the areas are defined in Annex A, at page, if you want it, at page 946. I'm not sure you've got the maps in this, but you see Annex A at 946. And they are to be military bases, as one sees, if one goes back to 944, as one sees from Article 2.2. And what this treaty then does, just to show you the structure of it without getting too sucked into the detail, which is perhaps not critical for the purpose of the arguments before this court, is in various annexes, and one sees the reference to Annex C in Article 4, to Annex D in Article 6, to Annex E in Article 7, is by reference to the detailed provisions of those annexes, which span a large number of pages, as you see from just flicking behind the main body of the treaty. It sets out the new relationships and the various ingredients of the relationship between the new republic and the United Kingdom. If one takes Annex B as an example, Annex B starts at page 948, and it covers matters such as, if one goes to Annex B, Part 2, Section 1, Sub 1, on page 950, two-thirds of the way down page 950, it covers things such as the continuing use of some sites in the territory of the Republic of Cyprus by the United Kingdom, and the right to go between the various sites and the SBAs with military personnel, as one sees, for example, from Section 4, Sub 1 on 952. It covers, again, things like, and they're only examples, if one goes further forward into Annex C, page 980. So we've had a fair few pages of Annex B before we've got there, but Annex C deals, amongst other things, with the status of UK forces. Annex D then deals with nationality of persons affected by the establishment, and so on. So you've got, even in the main body of the treaty, you've got a series of detailed provisions, in effect governing and regulating the relationship between the United Kingdom and the newly independent Republic of Cyprus. The treaty also included, and one saw it back at page 942, an exchange of notes between the UK and Cyprus, covering all sorts of different matters to do with their relationship. And one sees those notes, the various notes, behind tab 28 in this same bundle, starting at page 1011. And perhaps there are a set of them, including to do with the continuation of various loans and financial arrangements and all of those matters. But if you go forward to the exchange of notes that is starts at page 1018, you'll see that there are a series of detailed provisions which go directly to that relationship and the administrative and governmental relationship between the new republic and the sovereign base areas. You see the intention of it from perhaps the second paragraph of the letter to Archbishop Makarios and Dr. Kutchuk on page 1018, second paragraph of that, determined to stand by that declaration and thereby create continuous and lasting system of administration in the sovereign base areas, founded on close cooperation between the authorities of those areas and the authorities of the Republic of Cyprus. That's the purpose of it, and presumably they did this exchange of notes with the declarations attached because this was a looser form of international cooperation, but still containing strong expressions of intent as opposed to the binding provisions of the treaty. I think that probably distinguishes the form of these things. But you see the declaration on page 1019. Her Majesty's Government, I'm reading from below the title on page 1019, Her Majesty's Government declare that the main objects to be achieved are effective use of the sovereign base areas as military bases, full cooperation with the Republic of Cyprus, protection of the interests of those resident or working in the SBAs. And then can I invite you to read too, including in particular the declared intention of Her Majesty's Government not to develop the sovereign base areas for other than military purposes, not to set up and administer colonies. So one can see immediately the political sensitivities, apart from anything else, of describing the SBAs in any form of colonial language. But there's a positive declaration not to set them up in that way. A modern familiarity at 2.3, not to set up customs posts or other frontier barriers. Today's echoes resound. 4, not to set up or permit the establishment of civilian, commercial or industrial enterprises, except so far as connected with military requirements. Not to establish commercial or civilian seaports or airports. 6, not to allow new settlement of people in the sovereign base areas other than for temporary purposes. So those are the, as it were, the UK undertakings, the basis on which these sovereign, newly sovereign and sovereign nations are setting up their relationship with serious restrictions. Not a colony, not setting up and administering colonies solely for military purposes, nothing civilian or commercial about it, and no new settlement other than for temporary purposes, but nevertheless trying to achieve a workable way of managing that governmental relationship. So you see, for example, under legislation at the bottom of the page, page 1019, the laws applicable to the Cypriot population will be, as far as possible, the same laws as the laws of the Republic, and the specific provision that needed to be made, even for things as basic as public services. At 4 over on page 1020, the Republic will be invited to provide a wide range of public services to be performed for Cypriots in the sovereign base areas, and you see the various things which are specifically contemplated at that stage.
What makes them Cypriots? In other words, obviously when Cyprus was a colony, I suppose one called everyone there a Cypriot, but when the sovereign base areas, with apparently Cypriots, some Cypriots living in them, remain sovereign territory, what happens to their nationality? Or, and presumably they only have, they appear to they have complete freedom to move to Cyprus. They have freedom to settle in the Republic of Cyprus. They presumably don't have freedom to come to the United Kingdom. What is it that regulates that, all that?
My Lord, I don't know the answer to that off the top of my head. I suspect it's probably regulated somewhere in here. My understanding is that I think the position is, but I'll check, that they retained or they became Cypriot citizens or nationals of Cyprus at that point, and therefore had the right to live in either place. They could settle
Well, it's quite interesting when you come to
to the
about
substantive
comparing
articles
them with
refugees.
Refugees.
Right.
One ought to have some understanding of what the rest of the local population is.
My lord,
like.
yes, but my understanding is, and we'll double check, is that if you're a Cypriot living in the SBAs, you have the right, as it were, to move freely across the border, not to the UK, but across the border to Cyprus and settle there.
Paragraph 3 seems to suggest that Cypriots do not include non-citizen residents.
Where's that?
Well, the rights of, it refers to the rights of Cypriots and other residents in the Republic. It seems to suggest that persons who are resident in the Republic but not Cypriots are not to be treated as Cypriots appears to refer to their nationality rather than their place of residence.
Yes.
Yeah. It appears to be covered by Annex D to the treaty, which begins on MS 996.
My lord, yes.
(916).
996.
It's Article 6 of the treaty itself on 944, which
Yes.
refers you to Annex D for the arrangements concerning the nationality of persons
Yes.
affected by the establishment of the Republic of Cyprus.
So it says what their nationality rules shall be.
Yes, section 4.1 in particular, perhaps on page 998. Yeah, well, I'm very grateful. Those are the detailed provisions. Thank you.
Did you refer us to a map showing where?
I did, but it wasn't in.
Yes,
Rather irritatingly.
looking.
There's one at the back of Mr. Justice Foskett's judgment, but I don't know quite where that one came from. So in Mr. Justice Foskett's judgment, if you want a geographical flavour, page 469 in Core Volume 2. And you see the shaded areas on that. So Core Volume 2, 469. Setting out the Turkish administered area and the... Yeah. But I'm not sure quite where that derives from, but there certainly was a map referred to in the treaty, but I don't think we've got it in the bundle.
Well, it won't be that one. It won't be this one.
It won't be that one, no.
This is after partition.
Yes, it won't be that one. But I suspect that the shaded bits...
The sovereign base areas
might be
are in the
pretty
same
similar.
place, yes.
Yes, if not identical, because they're defined in the treaty itself, as we've seen. So
Is it somewhere in the papers relevant? Plan?
I haven't come across it, but that may be as much my indolence in
If
terms
someone
of
could track it.
discovering it, but we'll track it down.
Are they the same as the maps exhibited to the administrator's first affidavit, first witness statement?
They may be. May I check?
I'd assumed they were, but maybe not.
Yeah. It's slightly strange they're not in with the treaty itself, because they were obviously a part of it. So those are the key provisions. Those are the key provisions of the new setup, and there's quite a helpful description of the state of its government. That's the state of the government in the newly created areas in Authorities 7 again, if you go back to that. Keep Core Volume 3 out if you will, because I'm going to go back to it in a second. But in Authorities Volume 7, behind tab 73, there is a helpful article, and there's another one in 1963, which is also helpful in the next tab, but behind tab 73, 5144 for those who are on the electronics. Authorities 7, tab 73. This is J.E.S. Fawcett. I think,
James Fawcett, who became president of the European Commission on Human Rights.
and was, I think, a former Foreign Office legal advisor, if I remember correctly. Yes, exactly so. I think the same.
Certainly.
Certainly the same, I'm grateful.
When did you write this?
1949, says my note. We had that specifically on it, but
Yes.
but it's 1949, I think. And he describes at 5150, it is 1949, yeah. At footnote 7, at least a broad classification of the sort of government that is in place. Footnote 7 on page 5149. Sorry, so this is 1949, so this is before 1960, before independence, and you see that he classifies Cyprus, if you look over on the next page, 5150, still within footnote 7, he classifies them in various different ways, the overseas territories, the British possessions and protectorates, as he describes them. And you see capital Roman 2, possessing representative government with an elected element, having an unofficial minority at 3, Cyprus. So, and the various institutions at that point in time, or round about that point in time, we've set out in post-hearing submissions to the Court of Appeal. If I can just give you a reference and invite you to put it next door perhaps to that footnote, Core Volume 2, tab 19, page 776. And just on the state of government before the major changes, as it were, there's a colonial report, so-called, in 1954, and that's in, you can put Authorities 7 away, if you take up Appendix 2A, Roman 1. Jump around. And you go behind tab 43, page 1165 on the electronics is the start of it. And one sees, again, I'm not going to go through it in any great detail, but one sees the description, I think it's a question my Lady Hale put to me, 1166, you see under government, the nature of the governmental structures that existed before the change, as it were. So these are all at the time, or round about the time, or leading up to the original notification for Cyprus in 1956 of the Refugee Convention. That's why we're interested in what its state of government looked like. Maybe I thought about the consultations, but one sees the state of government there described. Population is perhaps rather less interesting. But then under administration, on page 1169, again, I'm not going to go through it in any great detail, but one sees the structures, some of which we saw earlier on in the setup documents that I took you to at the outset. The Executive Council referred to in the first paragraph, and then after it became a colony in 1925, see the final sentence of that first paragraph on page 1169. Legislative Council enlarged in that way. Disturbances in 1931, but the Executive Council is retained midway through the second paragraph. And you see its function described in the second half of the second para on page 1169. And then flowing down the governmental hierarchical tree, bottom paragraph, village commissions, over the page, second para on page 1170, municipal corporations, district commissioners and district councils and so on in the final two paragraphs on page 1170. So I hope that gives at least a flavour at the relevant time of the nature of the governmental setup in Cyprus so this is 1954, this description, and this is 2 years, but therefore before the notification is given under the Refugee Convention. Sorry, I've gone back a bit in time, but just to pick up those references. So the next development in terms of the creation of the new independent Republic of Cyprus is the domestic legislation that deals with the new setup. We've dealt with the international provisions that set it up and the way in which they worked. Domestically, what happened was that there was a Cyprus Act of 1960, back into core volume 3, if you would, behind tab 29, 1026. And for your note, it's Mr. Justice Foskett at para 53.
Sorry, which tab?
It's tab 29, my lord, page 1026. And so this is an act which is made on the 29th of July 1960, see the long title at page 1027, and you see its purpose. The date is a date, in effect, preceding the signature of the treaty, which was August, as you will recall. So this, I don't want to get into acts of parliament authorising treaties to be made or withdrawn from, but this is a few months before, and so would have been unhelpful to an argument I made in another place at another time, but there it is. It's made before the international agreements in question. The key provisions of those in sections 1 and section 1 and section 2 sub 1. If I could invite you just to cast an eye down those. So it anticipates, in effect, and is consistent with the international agreements that then followed, setting up the independent Republic of Cyprus, splitting out the two sovereign base areas, and preserving the sovereignty and the jurisdiction of the UK in relation to those areas, and providing for Her Majesty to make laws in relation to those areas. There is then, in the next tab, tab 30, an ordering council, and this is dated a bit closer to, but still before, the signature of the treaty itself. And you see the establishment of the Republic of Cyprus Order of 1960, page 1037, and the relevant clause for present purposes is clause 2. And what that does is to bring in the relevant constitution for the new republic on the date that you see there recorded, which is the 16th of August, which was the date on which the treaty is then signed. So you can see this is all being done in anticipation of the signature. No doubt there were some pretty serious discussions that had gone on for some time before this stage was reached. There's then, and so that deals with the Republic of Cyprus and the setting up of the new sovereign body there. There's then a sovereign base areas order, in effect, at 1038 in the next tab, tab 31, and that sets up the equivalent new arrangements for the SBAs, including the provision for an administrator to take on the burdens of the powers and duties conferred on him under this order. That's section 1, or clause 1. Power to make laws, clause 4. Existing law continues in effect, clause 5. There was also, and we can perhaps get it overnight, I'm not sure it's made its way into the bundle, but there was also an order in 1962, so a couple of years later, precisely demarking the boundaries of the sovereign base areas. So I think the position was that after the treaty was signed, there was still a bit of discussion and negotiation about the precise boundaries of the SBAs, and they obviously were then finalised in, no doubt, some agreement, which is reflected in an order of 1962, which will get you overnight. But I was puzzled by that. But that's the way in which the boundaries of the SBAs were finally settled. So some continuing negotiation and discussion with the newly created Republic, leading to the firming up of those precise boundaries. So that's the basic setup by which nationally and internationally the new Republic and the SBAs were created. And I'm sorry if I had to jump between various bits, but I hope that pulls that bit together in one place. So that's the fourth of the key developments. The fifth of them is a negative one, which is that the UK did not notify withdrawal of the declaration or the notification that it had made in 1956 that we saw in relation to Cyprus. It did not notify withdrawal of that notification in 1960. But the Republic of Cyprus notified its intention to be bound by the Refugee Convention on the 16th of May 1963. I think you find that at Appendix 2A, Roman 1, tab 54, MS 1242. I don't invite you to turn it up now, but that's the reference if you want it. So that was signing up, as it were, to the Refugee Convention in its original form. But as you're aware, and this is the sixth of the developments, in 1967, there was a protocol created to the Refugee Convention. And if you still have Core Volume 3 open, it's behind tab 24. I think it's in a variety of different places, but the 1967 protocol starts at page 925 in the electronic numbering behind tab 24. I invite you to cast an eye down the preambles. Those were quoted, if you want them, in Mr. Justice Foskett's judgment at para 29. And the relevant provisions, again, just to flag them, Article 5, that deals with accession. And Article 7, 4, is part of the continuation provisions of the reservations and the notifications and declarations that have been made under Article 40 that we saw.
Sorry, which provision are you referring to?
I'm referring to Article 7, sub 4 on page 928. You see, just picking it up, you see the reservations continue to apply if you sign up to this protocol in Article 7, sub 2, and then sub 4 is in the terms you see.
Must be a principle of international law, must there not, one supposes, that if a state loses territory irrevocably and accepts, for example, by a treaty that it has lost it, then treaties which it's entered into are pro tanto restricted to the remainder of its territory.
I think there is such a principle. I'll find it, but there's certainly one of the articles on succession that's in the bundles refers to precisely that, the shrinking and the expanding.
Likewise, if you expand.
Dilemma.
Right.
Yeah. But you see what is said in relation to Article 7.4 at this point. So bear in mind, we're now in 1967. And of course, it couldn't be so deemed in the case of Cyprus, in inverted commas, under the previous declaration, because, or not least because, Cyprus had committed to it in its own right by then. That's to the original convention. As we saw, it did that in May 1963. But even in relation to this convention, it was acceded to by the new republic as a newly independent state, as it were. It was acceded to on the 9th of July by the Republic of Cyprus, 1968.
But when you say this,
The protocol.
the protocol.
The protocol.
Yes.
So the protocol is 1967. It's acceded to by Cyprus in its own right. And one sees that, sorry, you've got this same document in a variety of different places. I've taken you at 928. But if you go to the other place where this protocol is at, in the same volume behind tab 33, it's exactly the same but with a different typeface. Protocol running between 1062 and 1064, but it has the additional bits and pieces telling you when various states acceded to it or succeeded to it, and containing the various declarations and reservations that were then made. So if you see Cyprus, page 1065, right-hand column, about 6 down in alphabetical order, that's where I get that date from. And you see it acceded to it in its own right on that date.
Of course, that was quite a dramatic step, because the 67 protocol greatly expanded the scope of the original convention.
My lady, it did, and I should have said that by way of introduction to it.
It
You're
really
right.
is rather an important step.
It's quite an important step.
Because
because
the original convention was bound to eventually disappear.
Yes, and the effect of the protocol, if I've understood it correctly, was that it expanded the reach of the original 1951 convention, both geographically and temporally.
Temporally being the big...
Temporally being the key one, exactly. So that the refugee events, if that's the right way of describing them in question, could then, the prospective events could then be covered as well. So it was a pretty important thing. But they sign up to it on the 9th of July 1968.
And what's your position about the application of the protocol to the bases?
I'm going to come to that. I'm going to come to that directly. So that's the declaration provision, Article 7.4. And again, if you go back into Mr. Justice Foskett's judgment, Core Volume 2, Tab 5, and you go to... Actually, we perhaps don't need to go there, sorry. You can go there if you want it, but this, I think what he there quotes is in that same tab, 1066. And if you go forward to 1068 in, Core Volume 3, I'm sorry, I've given you a false trail, Core Volume 3, back into the same document we were just looking at, this time page 1068, if you would, at bottom of the page. So at this stage, the United Kingdom does make some of the declarations of the kind that we've seen contemplated by Article 7.4. And as you see from the right-hand column at the bottom of the page on 1068, it does so by excluding from the application of the protocol certain territories for whose international relations it's responsible, Jersey, Southern Rhodesia and Swaziland. And then that's A, and then in B, positively extends the application of the protocol, no doubt having discussed matters with them, to other territories, there St. Lucia and Montserrat. And if you want an explanation as to why Jersey, amazing the intricacy of the weekend, why Jersey was excluded, you find the answer to that, if you want it, at Appendix 2A, Roman 1, tab 61, 1255, and Jersey were excluded because they didn't want to be included.
What was it? What was the reference again?
Appendix 2A,
61. Yes.
2A Roman 1,
Yeah.
tab 61, page 1255, and that indicates that they positively wished to be excluded. And so you'll see as well that in relation to those declarations under 7.4, the SBAs are not referred to in either camp, not the excluded camp and not the included camp. Why that
Quite a lot of other territories for whose international
Right,
relations
so why
the UK is responsible aren't mentioned.
Yeah, why that is less clear. Either no one thought about it, or they thought in relation to the SBAs, and I'll come to this, that it might have lapsed the original Article 40 declaration, because you'll remember that there was a deeming provision that continued then, so that's at least a possible explanation. So that's what I wanted to say about the facts. I'm sorry it's taken a little while, but I hope that's been
What was the position in relation to St Lucia and Montserrat before? And
before in relation to the 1967 protocol?
Before the protocol. I mean, that might be quite instructive. Because there are so many places left out,
Yes.
neither included nor excluded. Was the assumption that they would continue to be included if they were already included? And was there a particular reason for extending it to St Lucia and Montserrat? You don't have to answer that question immediately, but it would help me with understanding what was going on here.
I will see if I can find an answer to that.
Thank you.
Yes, I don't know, but the position, as you'll recall, is that the deeming provision in Article 7, sub 4 of the protocol deemed the declarations or notifications that have been made under Article 40 to continue.
That's right.
So there is an oddity about saying, well, I'm not going to let that operate. I'm going to positively extend, as it were.
Maybe it hadn't been extended to St Lucia and Montserrat before. But that's pure speculation.
Yes, but then they'd have to give another notification under Article 40 this time of the original convention, one suspects, rather than simply doing it by reference to this deeming provision.
Very true.
But it is, my lady is right, it is an oddity, because they could have just let, in relation to St Lucia, they could have just let the deeming provision operate. And it may be that they thought, well, given that we're excluding some and extending others, then I don't know. We'll see if we can find out. Yeah, I'll come back to after lunch. We may have an answer. Can I turn to the submissions on this first issue? The first submission that we make is that there is good reason for territorial application clauses generally. That's the sort of clause we saw in Article 40 of the Refugee Convention. Those clauses are designed to permit states to deal separately by declaration or notification with territories for whose international relations the state is responsible. And so those clauses recognise the general rule of customary international law reflected in Article 29 of the Vienna Convention on the Law of Treaties, which is that a treaty normally applies to all the sovereign territory of the state concerned. And they recognise that that general rule, that otherwise applicable rule of CIL, reflected in Article 29, creates a tension in a situation in which a state has overseas territories under pretty much whatever constitutional arrangement. Put another way, it's premised, that sort of clause, that territorial application clause, is premised on a distinction between the metropolitan territory and the overseas territories. And there are, if one thinks about it, obvious and good reasons for such a distinction in the case of a state like the United Kingdom, and no doubt other states with colonial past or even presence. different social and practical issues might arise as between the metropolitan territory and the overseas territory. Should the treaty apply at all? And if so, on what basis? With what reservations? Different local laws might apply and need to be taken into account in decision-making about whether to bind an overseas territory to a particular treaty. And of course, there are different interests in play at a very basic level, local inhabitants having their own particular local interests, represented to a greater or lesser extent by local constitutional organs. And it's proper that they should have their say. And all of those sit alongside, all of those features sit alongside the fact, the international legal fact, that it is the state, the metropolitan state, if I can call it that, which is responsible for the international relations of the overseas territory. So the overseas territory, what that means is that the overseas territory can only act on the international plane through the mother state. See, if you will, and I can take it from our case perhaps most conveniently if you have that to hand at paragraph 10. See the explanation given by the learned editors of Oppenheim that is there quoted. Leading, as it was perhaps neatly put by Sir James Fawcett in 1949 in the article we've already seen, to the antimony between the dependent status of the overseas territories and their capacity for self-government. It's that thought, and one has similar reasoning published by the UN itself on the basis of clearance, if that's the right way of putting it, from the UK, a published document in 1953. If you go to Authorities 6, Authorities Volume 6, tab 65, page 5050. You see the date and nature of the document from the 5050 page, and its data's at the bottom, as you see, 1953. And one sees, inter alia, by reference to Sir James Fawcett's article of 1949, see footnote 2 on page 5053. You see the description that is there given, in particular in paragraphs 8 and following. Paragraph 8 begins at the bottom of page 5052. And again, if I could invite you just to cast an eye, if you would, over para 8 through to the end of para 12 on 5054. Again, you only need to skim it to get a sense of it, but perhaps leave para 10, which is of less interest. So the passages I particularly highlighted, if I may respectfully recommend them, are the third line on page 5054 to the end of that paragraph, and in particular para 12. You saw the reference in footnote 2 on 5053 to the Fawcett back to the Fawcett article. If you put volume 6 away and take up volume 7 again, if you would, and back to tab 73, and the passage I particularly wanted for this purpose begins on page 5163. Which is in effect a summary of, of his conclusions from the reasoning that's preceded it on the previous 20 or so pages. And so could I invite you to read 5163 under conclusions, if you read, if you would, down to the end of point 5 on 5164. You'll see the echo of the language in 4 and 5, my lady has it. And so, I can put that away, so, if I may put it this way, territorial application clauses come into being, and it's those features, those good reasons for territorial application clauses generally, that lead to an understanding as to what it is that was being done when those clauses were inserted and operated. States in question having discussions with and getting the consent of the overseas territories to bind it and its people, that's the overseas territory and its people, to the treaty in question. No question of automatic application to all territory over which sovereignty is exercised, contrast the usual rule in the Vienna Convention under Article 29. When and if that is done, the equivalent of Article 40 is operated, the state makes a declaration on the international plane because it is responsible for the international relations of overseas territories, and that's the only way diplomatically and legally that one can do it on the international plane, but it is doing so on behalf of that territory and its people and after consultation with their consent. That's what's being done once one understands the nature and purpose of those clauses. So that's the first point, good reason for territorial application clauses generally. The second point is that Article 40 of the Refugee Convention, which we've seen, is an example of such a clause and was evidently intended to operate in this way for the reasons I've just given. And if one wants a specific recognition that that is indeed the way that Article 40, entirely consistently with that thesis, was intended to operate, one finds it very clearly set out in the Travo to the Refugee Convention. And again, I think if I can take this most conveniently from our case to save you having to jump around, we have quoted in our case at paragraph 12 quite a long section of passages from the Travo quoted by Mr. Justice Foskett. We've given you the references to his judgment there. If you want the original, we've given you the reference into his judgment in paragraph 12, but if you want the Travo in the raw, they are at Authorities Volume 6, tab 59, page 4797 and following. And the UK one is, I think, at 4798, but maybe 4797. But if I could invite you just to remind yourselves of what the delegate of the UK said, as is recorded in the passage, the second of the paragraphs within that quote in our case at para 12. But one sees, if one flicks over the page, that different states came at it in a slightly different way with the various different justifications that I've outlined for clauses such as Article 40 in this very context. So one sees what France had to say and what Australia had to say, which are there set out. But from the UK perspective, the very purpose of the clause was to enable the colony to decide for itself whether to undertake the obligations in the treaty, and thus to prevent what would otherwise be the automatic application of the treaty to it. And as others indicated, it also had the advantages which don't depend on the precise extent of autonomy of the colony or the overseas territory, of enabling different social conditions, for example, to be taken into account, different local laws. So it's about not merely autonomy, but it's about the particular conditions, practical, legal, and social, in the overseas territory. So that's the second point, Article 40 as an example of a clause operating with those purposes behind it as recognised in the Travo. The third submission is that it's evident, therefore, that territory, in the context of Article 40, does not mean land. It means political entity. And that is supported, we submit, by the English text of Article 40, which refers, as you will recall, to territories for international relations of which the state is responsible. So in the context, that plainly doesn't mean land. It's referring to something for the international relations of which the state can be responsible. So it's plainly referring to a political entity and the people so represented, not to physical land. And the French text, which is equally authentic, you had, if you want it, behind in Authorities Bundle 8, behind tab 97, page 5498 is the first page, and the relevant part is at 5505. See Article 40. And you see the reference in particular in the second line of sub 1 to à l'ensemble des territoires qu'il représente sur le plan international. So that is a specific reference to territories that are represented on the international plane, with its flavour.
The page number again.
Yes, I'm so sorry, my lady.
I was writing before.
5505, and it's really the second line and the reference to territories qu'il représente sur le plan international, which is the same flavour, but as it were, carries more of the representative feature, the on behalf of idea. Representing them on the international plane is the sense in which responsibility in the English text is used. And that supports the notion, we respectfully submit, that in this context, territory does not mean land. And it's entirely consistent, of course, with the concept of the Article 40 notification or declaration being given on behalf of the political entity. And for that reason, I'll come back to the reasoning of Lord Hoffman and the House in Bonku number 2. But for that reason, amongst others, we respectfully submit that in this context of the Refugee Convention, but more generally, the House were plainly right to conclude, at paragraph 65, which we'll go to in due course of Bonku number 2, that a declaration of this kind, as it was put by Lord Hoffman, applies to a political entity and not the land which is from time to time comprised in its territory.
But the political entity must relate to land, or indeed some sea as well, but it must relate to a physical, geographical. It may be a variable one, which is your point, I think, about Bonku, but the political entity must have a meaning, and it must relate to the land over which that political entity
Certainly, in the sense that
has control or government or whatever.
Political entities are undoubtedly linked to land. I fully accept that, but this is a concept here which is not, as it were, simply referring to the physical land. It's referring to the entity itself, and that flows from being representative and on behalf of, and the fact that very difficult to see how you can be responsible for international relations if you're not responsible, as it were, to the political entity itself. And it places, therefore, the focus on whether, in relation to changes after a declaration is made, the political entity itself survives.
Are we responsible for the international relations of the South Sandwich and South Georgia Islands?
I think we still are, yeah.
Well, they don't have any inhabitants, do they?
Well, my lady, no. But if you're on the general proposition that it is linked to land,
before there's any political entity involved. I know they have a government and whatever, but as an actual political entity comprising people and a population, they don't, do they? They have temporary visitors as scientists.
My lady, they do, and no doubt the international relations of those areas is subject to the United Kingdom's responsibility. So there can be circumstances
Definitely.
in which it's land only, if one posits an example where there are only penguins. But my lady is, of course, right. But nevertheless, the sense of it remains. I'm not sure that necessarily destroys the thought that it ordinarily applies to political entities. And so we respectfully submit that the question of continuing effect of a declaration isn't answered by, to come back to a point that was made to me by Lord Mance, it isn't answered by the continuing effect of a declaration, isn't answered by a mere expansion of land under a state's control. So, for example, Germany annexing Austria in 1938-39, the UK annexing Cyprus in 1915. Germany and the UK plainly continued, and a mere contraction of land the same. France and Algeria. When France divested itself of Algeria, it didn't cease to be France. So we respectfully submit that the mere fact that the land of the old entity stays under the control of the state isn't significant to the analysis. The fourth submission relates to sovereignty and the impact of sovereignty on these issues. Of course, declarations made under territorial application clauses assume the continuing sovereignty of the state giving the declaration. That's the very premise for them. Otherwise, the issue wouldn't arise. But the whole purpose of these clauses is to recognise that separate issues arise, despite the ability to exercise sovereignty in the sense of responsibility for international relations, in deciding whether the political entity that is the territory, for Article 40 purposes, should be bound by the treaty obligations. So the existence of sovereignty over the territory is thus, by definition almost, not the test, it is the premise for the application of Article 40. And if there is a change to the political entity, the question that then arises is whether the declaration made in relation to the old political entity continues or can survive the change. Of course, if sovereignty has gone, as in the case of the Republic of Cyprus itself, no question of a new entity arises. The declaration did not, without more, continue to bind the ROC. So again, sovereignty for the remaining part of the old entity is simply the premise for the question arising. In principle, we submit sovereignty isn't the appropriate test anyway. Declarations are given in relation to particular political entities, and indeed land for this purpose, attached to the political entities, having considered all matters including local views, practical matters such as the ability to conform to the obligations in the treaty. So the judgments that are made about binding a political entity in that way are made in a very particular context. I mean, suppose for the sake of argument that the old entity becomes independent, but 500 yards of land, say, is retained under sovereignty or control. I'm positing an example of continuation of sovereignty over a small strip where it would plainly be impossible to satisfy the obligations or the continuing obligations under the treaty. That demonstrates that a mere continuation of sovereignty can't sensibly be the yardstick. To put the same point a slightly different way, even if sovereignty is maintained over some part of the old entity, you would still be dealing with new entities raising serious questions, political, policy, practical. You can't assume that it just carries on because sovereignty carries on, is a submission. So the fifth submission is that once the basic nature and purpose of these sorts of clauses is understood, that informs the understanding of the 1956 notification in relation to, quote, Cyprus. In 1956, as we've seen, Cyprus was a colony with its own local interests and its own, albeit fledgling, representative structures. Remember the colonial report. And the 1956 notification that we saw behind tab 26 of Core Volume 3, Electronic 939, precisely reflected that understanding. Prior discussions, reservations in, and all the rest of it. And it then said, the convention shall extend to the territories of ... Cyprus. What is the territory, therefore, that is referred to for that purpose? It is, we respectfully submit, plain what it is. It is the colony of Cyprus, with its own local polity and its own local interests and its own social conditions. The notification under Article 40 sub 2, or even a declaration under Article 40 sub 1, is given on behalf of that colony. It's given in the light of a judgment at the time, 1956, that the colony, with its social conditions and its local interests, can and should be bound by the obligations in the Refugee Convention. It is given under a clause, the precise purpose of which is to avoid what would otherwise be the rule of international law, namely that all territory under the sovereignty of the UK is automatically bound into any treaty. It is not given on the basis that the UK, or merely given on the basis that the UK has sovereign authority over the physical land. Indeed, Article 40 is the antithesis of that, as I've already noted. The relevant sovereign authority that is engaged in Article 40 is the limited sovereign authority to give notification, because that's the way in which such notices can only be given, because the UK is the state responsible for the international affairs of the colony. And so we respectfully submit that applied to Cyprus, it is perfectly clear that the reference to territories in the notification is not a reference to the land, and it is not a reference to the land plus sovereign authority over it. It is to the political entity that is or was the colony. And that leads on, of course, to the sixth submission, which is that the entities that were created in 1960 were not, on any reasonable view, the same as the colony of Cyprus, on whose behalf the 1956 notification had been given. Just a couple of points in relation to that to develop it. Generally, there was, as I've already noted, a fundamental change, and the appeal court in the SBAs were correct about this, and so was Mr. Justice Foskett. There was a fundamental change in the status and constitutional setup of what used to be the colony of Cyprus. See for a description of those changes, Mr. Justice Foskett's judgment, paras 47 and following. It plainly was not the same entity as the one that took the obligations on through the diplomatic medium of the UK. And so it isn't a question, as the Court of Appeal thought, of shedding or abrogating obligations. The question is whether the obligations that were undertaken by the notification attach at all to the present-day entity or entities. And for the same reason, the comparison with Germany and Austria and its annexation of France and Algeria are simply not apt comparisons. The colony of Cyprus, as it existed in 1956, disappeared. One can analyse that by reference to the two constituent parts that were then created. What about the Republic of Cyprus? That was part of it. One looked at it territorially. But so far as the Republic of Cyprus is concerned, that replaced with a new independent state, the previous colony. Was the 1956 notification given on behalf of it, that is the Republic of Cyprus? Plainly, by definition, not. It hadn't been created. It was an independent nation able to make its own decisions about treaties and their continued application. And as it turned out, it informed the UN, as we saw in 1963, that it considered itself bound, an independent decision for it to make, by the Refugee Convention. Now, there are various ways in which that could have been done, and the law of succession and all of those points just lead to different and uncertain and complicated ways in which these things can be achieved. But the fact of the matter is that it made its own independent decision, that it wanted to be bound by the Refugee Convention and gave notice accordingly. What about the SBAs, the sovereign base areas? They are not the colony of Cyprus on whose behalf the 1956 notification was given. And we've seen the key features of the SBAs. Just to summarise a few of them, they exist solely for military purposes. They cover an area which is subject to all of the agreements and all of the constraints agreed between the international partners that signed up to the Treaty of Establishment, and indeed the newly independent Republic of Cyprus. They are very small areas. Their population is very small. Even today, it is now some 10,000 or so Cypriots under British sovereignty, but for most practical purposes operating within the structures of the ROC. And as we know, at the time, the areas of land were chosen because they were away from population bases, we see from at least some of the evidence that that was a deliberate decision. So not merely are the SBAs not the colony of Cyprus, on whose behalf that notification in 1956 was given, but they can't sensibly be viewed, we submit, as being some form of continued colony. They can't be so viewed legally, even leaving aside the evident political sensitivities of any such status following independence. And we saw some of those political sensitivities reflected, if you recall, in the declarations that accompanied the treaty. Not colonies, shall not set up colonies. You remember that provision. The only real common feature is that the land continued and the sovereignty continued. But even in relation to sovereignty, that's British sovereignty, that was circumscribed. And it was circumscribed by the agreements that were reached in 1960. But in all other respects, it was fundamentally different, politically and practically. Even, for example, in terms of practicalities, to the extent of matters as basic as power and water being provided to the SBAs through the newly created Republic. There was a wholly different system of government, and there were new mechanics of interaction with other parts of the island and its government, inevitably, given the creation of the new republic. So what's the precise status of the SBAs? Well, the answer to that is probably, even if it's a bit of a duck-out, sui generis.
I was going to ask you that question. I was expecting that's what you'd say.
Yeah, well, you now have the answer for good or ill. But they are a new entity or beast with a new order in council, as we saw, its own constitution, as we saw. But it perhaps doesn't matter precisely what status or label one attaches to it. They were evidently new, with new legislation. And if one had said in 1960, for the purpose of our argument, that there's a new colony, or they're a new colony, or a new British overseas territory, to use the more modern formulation of it, if one had said that in 1960, would that have made a difference? Very difficult to see how.
Why is it relevant that there was a new administrative arrangement? I mean, presumably you do not alter the identity of an international law entity simply by making different arrangements for its administration.
My Lord, you don't. But I think it goes to the nature and scale of the change, whether one can sensibly see this as a continuation in other guise, as it were.
Administratively, clearly it wasn't a continuation, but my question really is whether that actually is relevant.
My submission is it is relevant because the relevant legal question, which I'll come on to as set down in Bonku, is whether or not you are or are not dealing with a new entity. And if you're dealing with if that's the relevant question, then all matters bearing on that, including the nature and extent of any administrative changes, are, I submit, relevant.
Is the involvement of the Republic of Cyprus in aspects of the administration, its involvement, for instance, in the provision of social services and the like, as foreshadowed in the 1964 declaration, is that relevant to the question that you're now making submissions about?
My Lord, it is, as part of all the circumstances, and it serves, that feature, amongst others, serves to indicate that what one is dealing with is not simply a continuation of the old beast, but something which is genuinely and properly to be described as a new entity.
Because large numbers of the aspects of statehood
are exercised
in the hands, effectively, of another entity.
Exactly so. And indeed of the practical arrangements, as we saw from things as basic as power and water being provided into those areas. And the constraints on which it works both ways. It works both in terms of the impingement of ROC sovereignty into the SBAs, and it works in relation to the constraints on the British side of sovereignty as to what they can do in those sovereign base areas. Only limited purposes, not colony, not settlement other than on a temporary basis of new individuals.
It sounds as though you're treating the question essentially as one of fact, that you determine as a matter of fact and degree according to the overall circumstances.
Well, my Lord, I think if one applies the Lord Hoffman test from Bonku, it does look remarkably like that, because the question is there a new entity? So there will be factual aspects to that, and you'll need to look hard at the nature of the new setup to see if you're dealing with something different. But you'll understand at the most basic level, ours is a rather simple proposition, which fundamentally flows from the on behalf of submission that I made. In other words, this isn't the same beast on any view as the beast in relation to whom the original notification was given. But the question is, what is the effect of that?
Does it depend on the particular treaty we're talking about? So the sort of factor you were discussing with Lord Sumption comes in, or is the one question for succession to all treaties, or continued application of all treaties?
Well, my Lord, I think no one, I think, has got too far into all the intricacies of the laws of succession under international law, which we know when we come back to some aspects of that.
Yes,
yes, but there isn't a ready answer there, either in practice or in law, state practice or in law, that says.
But your test, does it, in other words, vary according to the needs and obligations contained in the particular treaty, or is it a sort of one-off test which would apply to all treaties to which the UK had on behalf of the colony of Cyprus acceded? I think, you'd probably say it applies to all of them, don't you?
I do at its most basic level, because the original notification, which is where you start, is given on behalf of a political entity. And the question is whether that survives. If the answer to that is no, whatever the precise...
Might it survive for the purpose of some treaties which could continue to be operated and not for the others? That is, I suppose, the real question. if you look at it on a treaty-by-treaty basis, you then start to ask, well, what is it about this particular convention which makes it difficult or to apply to the sovereign base areas, or inconceivable that it should be continue to be applied, which is to some extent part of your argument because of all the farming out of arrangements and the oddities of the sovereign base areas and their limitations.
Yes.
But I imagine you would also say there probably like to be difficulties of that sort in relation to most treaties which require, but perhaps they're not so great in relation to
there are, and they may not
others.
be so. They may not be so great, and to some extent, I don't want to drift too far into it at the moment, but that may be part of the answer to the MLA treaties. Remember the Mutual Legal Assistance Treaty, on which my friend places quite a lot of reliance. I mean, and it, as I say, without disrespect to anyone who
they can easily be dealt with because there's a legal administration there.
There's the address to which you send the single thing. So there may be differences. My submission is it's not a terribly pure way of doing it, and intermittent and slightly convoluted state practice, if there is any, is not a terribly good yardstick. So the answer is probably in principle purely all treaties, but even if treaty by treaty, there may
purposes of this treaty,
there may be very right.
It can't sensibly be treated as the same political entity.
Well, and or the ECHR, which I'll come to.
Yes.
And there is a tale to tell in relation to that. So I don't exclude the possibility that there might be different answers for different treaties, even if the pure answer is all.
Mr. Eadie, could I ask you a wider point? In 1999 and 2000, the Chief Control Officer of the sovereign base areas declared all these claimants to be entitled to refugee status under the 1951 Convention. Can you just explain, at some time convenient to yourself, why we are having issue 1 in the light of what appears to have been a concession that the Convention applies to these claimants residing in the sovereign base are's?
My Lord, I will. I'll take that away and think about it. But you'll have seen that. I mean, there's an academic flavour to all of these issues to some extent, because even if the SBA's even if the Refugee Convention does not apply in terms, there certainly has been an acceptance on behalf of the Secretary of State that the spirit of the Convention is to be complied with the greater flexibility that entails.
Was there anything in the original acceptance to indicate that this was being done on a sort of ex gratia basis?
I don't think there was anything at that stage. I'm quite
the concept of applying the convention in spirit,
except
ex gratia flavour about it.
Yeah,
whether that's actually what they did is another matter.
Right. Could I just, while we're on this subject, ask if at some stage we could be given a clear explanation of why this question of international law is being decided by this national court. I was thinking that it was because a decision had been taken under the immigration rules, or under the Immigration Act, applying the immigration rules, and there had been an alleged failure to comply with the immigration rules, but that might not be correct. In fact, Mr. Hussain is shaking his head. So it would be useful to be quite clear what the basis of our having jurisdiction actually is.
Oh, well, I think there is something of an explanation, but the fact of the matter is that no one has taken the favourite subject, which is international law's transposition into domestic law and how that occurs, and ex parte launder and all of those things that we almost argued in the Barclay brothers litigation, if you recall. Yeah. May I come back to that after a short adjournment?
Yes, of course. I should say I have seen Mr. Hussain's
his case
argument. I think refers to a statutory provision. If that's what the case is about, then that should be made clear.
My lords, my lady, the seventh and final submission before coming on to Bonku directly is that the consequences of the new arrangements just described for the continued application of the Refugee Convention, to come to that, were important in practical terms. it was important for the Republic of Cyprus itself to consider its position, continue or not, and if so, with what reservation. And in relation to the SBAs, an even more intensely practical set of issues was created. These were, as we've seen, military bases with restrictions on treating them like colonies, with restrictions on new settlement of people other than on a wholly temporary basis, dependent on the ROC for infrastructure, and serious questions, to put it at its very lowest, therefore, about the ability to deliver the Refugee Convention guarantees and rights if they're to be regarded as some form of continuing colony, continuing to be bound despite those changes.
Well, Lord Wilson's question indicates that those serious questions weren't in anyone's mind.
Well, they may not have been, and I'll see if there's a better answer to precisely why it was that they were ascribing status of that kind in that way. And we know that there's some talk in the evidence about the extent to which they went back to London, as it were, to give them assistance. And we also know that there are some structures that govern and have governed for a few years the treatment of people claiming refugee status, both in the SBAs and the ROC. There's a cooperative element between those two. So there may not be a terribly clear answer to my Lord's question, but I don't think anyone by that, as it were, by ascribing them that status, was intending to accept on behalf of or concede on behalf of the SBAs or the United Kingdom or anyone else that the full-blown Refugee Convention applied in the SBAs.
Perhaps we could look at those orders at some stage.
Yeah. My lady, that may be a convenient moment. I was going to go on to Bonku and the correctness of
7 more minutes.
Oh, well, that's very good. I'm sorry, that clock
is
fast.
Never reliable.
No.
My watch is not particularly reliable, so I tend to go by the clock on my computer.
Bonku number 2, then, if I may. Authority, volume 1.
I suppose this is your 8th point under this heading, is it?
Yes. Yes, I'd rather run out of numbering. Simply the correctness of Bonku number 2, in case the numbering got dull, as a separate subject. Tab 1 of Authorities, Volume 1, MS 2934. And it'll be very familiar to my lords and my lady, I know. You know the background involving the Chagos Islands.
It's one. It's number 1.
Volume 1 of the Authorities. Tab 1.
No. As I note.
It'll be engravened on your mind, so perhaps don't need the text. 2934 is the head note for those who need this purpose. The relevant holding in the head note is holding number 2 on page 2935.
Yes, we'd been thinking that Lord Bingham didn't express an opinion on this point, one way or the other.
He didn't, I don't think. But it was the relevant part of the judgment given by Lord Hoffman was expressly agreed to by Lord Roger, 116, para 116, Lord Carswell, para 120, and Lord Mance, 142. And Lord Bingham does not address it expressly, as my lady points out. So it does represent that finding, that holding, the view of the majority. Lord Bingham only not expressing a view, not dissenting on the point, just simply not expressing a view. And given that that is so, it brings in, I don't know, friends, fundamental challenge to this, which is that it sets the wrong test. It does bring in the principles on which this court overturns its own previous judgments. And again, I think you have all the authorities in the bundle because you'll well know them, but Nauer and the 1966 practice statement and all of that And the basic approach is that the court is very circumspect before departing from a previous decision. And it shouldn't refuse to follow an earlier decision merely because you would have decided differently. More than that is required, is I think the nature of the test and the way it's been put in Nower, not least because of the desirability of certainty in the law. I'm not going to go through all the other issues that arose in relation to this case, and they were myriad, but the key passage in the judgment in the speech of Lord Hoffman is at paras 64 and 65, pages 2970 to 2971.
And this proceeded entirely on the factual basis that Biot had been carved out of Mauritius, I think. I mean, something's been made in the arguments about it's in fact being an amalgam of islands formerly from Mauritius and formerly from the Seychelles, but that's not the basis on which Lord Hoffman proceeded, I don't think.
It isn't. It forms no part of his reasoning.
Yeah.
And I think it's common ground that it was actually carved out of two rather than carved out of one, if that makes sense, and an amalgam.
Because of the Seychelles?
Because of the Seychelles. We respectfully submit that makes no difference whatever to the nature of the principle that he espouses and sets out.
Do we know what facts Lord Hoffman regarded as decisive of its being a new legal new entity? It doesn't seem terribly specific about it unless it's somewhere else in this judgment.
I don't think it's anywhere else in the judgment. I think it's simply that a new colony is created.
I mean, if, as you say, it's essentially a factual judgment, then, I mean, this judgment is clearly binding for the proposition of law for which it stands, namely that if it's a new political entity, it's not bound by treaty obligations affecting the old one. But it doesn't bind us, does it, to decide that the facts necessarily justify treating it as a new entity in other cases?
My Lord, it doesn't. You're bound by the reasoning and not the factual application of that reasoning.
Yeah.
And there are two steps, as you would have seen. The first step is that the declaration applies to a political entity and not to the land that is from time to time comprised in its territory.
Yes.
That's step one. And step two is thus, if a new political entity, that must encompass the plural as well, is created, the declaration that is made by definition cannot be read as applying to it. And therefore a new one or some positive act is required to bind the new entity. The old entity's adherence to the treaty by an Article 40 declaration or something like that.
There's no suggestion at this point that Mauritius ceased to be bound by the Human Rights Convention. I suppose it became independent. That's the trouble, didn't it? Yes. Yeah.
Right.
Was there a gap in time?
I don't think there was, but
No, I think so.
I'm not sure quite when they signed up or notified or made a declaration.
The SBAs are such an extraordinary and unique entity that I question whether factual analogies with the British Indian Ocean territories are all that helpful. I mean, I agree they've got some features in common, like carved out of another larger entity, but there's rather more to it than that.
Yes, I'm not sure that that our focus is, as it were, designed to bring that comparison to bear on the argument. Yeah. Our focus is on the nature of the analysis, which effectively starts by saying on whose behalf was the original declaration or notification given. Can you assume, given the political developments that have happened, that that continues to bind, or are you dealing with a new entity in that sense? If you're dealing with a new entity in that sense, in other words, the comparison there is with the old entity, then you can't assume that it carries on and something new is required. So I don't need, for the purpose of my argument, to make, as it were, that comparison, or the comparison between the SBAs and what was going on here on the facts. My comparison is between the SBAs and, I would add, the newly created Independent Republic of Cyprus.
I should know the answer to this, Mr. Eadie, but I regret that I don't. But the military bases, which the sovereign base areas were created to protect and preserve, weren't built when on Cypriot independence, were they? They were already in existence.
That's certainly true of Akrotiri.
Yes, and it's Akrotiri, the airport, the Air Force.
Yes.
The sovereign base areas, it was my understanding, I could be completely wrong.
Already contained.
Were there to protect existing military bases, which were considered very important to the defence interests of the United Kingdom. And they wouldn't have been created just so that we could park new military bases.
No, I don't think we're dealing with virgin territory on which land, on which instalment.
So the territory on which, in respect of which the declarations, the extension had been made, probably already contained military bases with British military personnel there and attendant kind of, I don't want to use the word hangers-on as a kind of pejorative phrase, but
My lady, no doubt they did. But my answer to my lady, you won't be surprised to hear me say, is to repeat, as it were, that the true comparison is between the old entity and the new entities. The old entity, in relation to whom the notification had been given, was the colony of Cyprus, that is the entire island.
That's no surprise. I know
I
know what your argument is, but the reason that I intervened when I did was you talked about the people on whose behalf the declaration was made. And the sorts of people who are in the sovereign base areas were already there.
Maybe so, but I also talked, as you will recall, about the nature of the legal, political and social conditions, and indeed the practical conditions on the ground. And so if the thought is, well, it continues because the military bases were already there and some of the military personnel were already there, I respectfully disagree. And I disagree because the old entity, which is the true point of comparison, was the colony of Cyprus, with all of its infrastructure, most of which, 99% of which, is now taken on by the newly created Independent Republic of Cyprus. That is the true point of comparison. And so even if my lady is right, and I'm sure you are, to say that some of the military personnel would still have been there, the bases would still have existed, and so on and so forth, that doesn't assist, we respectfully submit. The analysis in Bonku number 2 is to compare the old entity, and underneath that, as it were, is the acceptance at a particular point in time on behalf of that old entity with all its social conditions, all its political ramifications, all its practical ramifications.
And with its administration to consult. And I suppose
and with its administration.
Say that once you become a sovereign military base area, you've got a completely different administration to consult.
Different administration, different practical concerns, different legal concerns. The question is it the same entity? That's why Lord Hoffman's question is interesting, we respectfully submit. And as in answer to my Lord Sumption, I accepted that the point of comparison is not between SBAs and what was going on in Bonku. The true point of comparison, which we respectfully invite the court to draw, is between the old entity, the colony of Cyprus, and the two new entities that are created.
Mr. Eadie, interestingly, there's a bit in the report of the argument about this, where the government, 294 to 295, 2954 to 2955, forgive me, says, well, it's the legal entity that's different.
Sorry, which page is this?
2954. Mr. Crow, QC, right down at the bottom. He doesn't actually use the word political. He says there's a new legal entity. And we may have to consider after the short adjournment whether Lord Hoffman was disagreeing with that or whether it might be a more helpful way into the inquiry, Mr. Eadie.
Yeah.
We're way over time now, Mr. Eadie, because we got into the argument. So shall we resume at something like 1:05? 2, I mean. 2. Thank you. We'll adjourn now.